All right, everyone, we'll start in a minute. Please sign into the attendance. All right, everyone, welcome back. We are almost done. It's scary to think about it. This semester is basically over. Today's our last real class. I had scheduled Wednesday for a makeup. We're not going to need it. No class on Wednesday. No, Macy, it's true. We're almost done. So no class on Wednesday. I got my shot, my second shot Saturday. I didn't have any symptoms, nothing. Everything was smooth. A little bit of soreness in the arm, but thankfully I was okay. I know others did not have it like that. I feel almost guilty saying it, but for those who are still perhaps on the fence, it's not guaranteed that you'll have symptoms. I had nothing. I woke up, felt great. So there you go. So we will not need the date on Wednesday. On Monday, basically a week from today, we won't meet. But I encourage you to use that hour and 10-minute block to try to do the exam from last year. That's actually 2 years ago, from 2019. I encourage you to do the entire exam if you can at some point before the end of the semester. I will be going over in class on Wednesday the first question, so part one of the exam. This is from spring 2019. It's on the syllabus. So I will be going over the exam spring 2019 in class on Wednesday. That'll be part one of the exam. All right. Questions? Okay. No hands up. I'll proceed. We are on our last topic today, which is the Second Amendment. And I got to tell you, I may not teach this topic again in the future. I'm on the fence. I mentioned last week in class that the Supreme Court has a case on its docket about the Second Amendment, a case involving concealed carry. There were also several cases involving the rights of certain nonviolent felons to have their gun rights restored. This morning, the court released its orders, usually Monday at 9:30 or 9:30 Eastern. And the court denied review in 3 felon cases. So the court won't take those cases. And the court relisted the carry case from New York. What does it mean to relist? It doesn't grant it. It doesn't deny it. It says we'll consider it again at the next conference. And usually when a case is relisted once, that's a good sign. That means the justices are considering it. But if it's relisted twice, that's a signal that the court's not going to grant it, and that there might be a dissent from a denial of rehearing. I'm sorry, a dissent from the denial certiorari. For example, the reading for today, the Justice Thomas opinion in Rogers versus Graywall, was actually a dissent from the denial certiorari. So at this point, it looks like the court's going to deny cert again, which really, signals the court does not want a gun case. Even with another, Republican-appointed justice, Justice Barrett, the court's still not eager to take a gun case. For the life of me, I can't figure it out. It's vexing. It's perplexing. It's a rhyme, good. But it's very confusing. So I just may take this off the syllabus next semester and spend more time on the First Amendment. I feel like I'm almost wasting my time talking about something that the court doesn't care about. Maybe you feel the same way. I don't know. Sucks for you because it's on the syllabus this year, but it's on my mind for next year. Just know that much. All right. I know you're like, oh, Blackman, why'd you assign it to us? I don't know. I'll think about it next year. I have to reassess. Okay. All right. Any questions so far? All right. So there are 2 cases on the agenda for today. Both were decided last spring during the previous term. Of course, this was before Justice Ginsburg's passing, so the court was still ostensibly 5-4 conservative rather than 6-3 conservative. But these cases were decided in fairly rapid succession. And they, I think, gave the most insights into the Second Amendment of anything we've had in a decade. All right. Who's up next? Who's up next?
I think I am.
Who's that?
I think I am, Catherine Dunn.
Okay, Catherine, sorry. I have way too many faces. I can't see all 8 of you at once. All right, Catherine. Walk us through the majority opinion, please, in New York State Rifle and Pistol. It's real short. It'll take you maybe 2 minutes.
So there was New York City had a law that prohibited the transport of firearms outside the city, which in which case people could go to gun ranges, and they changed it to where I guess you could go to one of 7 in the city, but 6 of them are members only, and I can't remember what the issue was with the 7th one. But
it was far. It was far. It was far. In fact, you may know this. I'm actually from Staten Island. Several of the plaintiffs here were from Staten Island, and let me tell you something. Going from Staten Island to the Bronx or Staten Island to Queens might be a 3-hour drive. I swear, my parents could sometimes get to Houston quicker than they could get to the Bronx. It just would take the entire day to get there. So several of the plaintiffs actually were from Staten Island, and they wanted to go to a gun club in New Jersey, which was 5 minutes away over the bridge, and no membership required. All right, so go ahead, Catherine. I didn't mean to interrupt, but I had to inject that one little part.
So the court decided that because the city repealed the law, they dismissed the case as moot, and basically said they go through the, to become moot the ordinary practice is in disposing of the case has become moot on appeals to vacate the judgment with directions to dismiss, and where the plaintiff may have some residual claim, the practice is to vacate the judgment and remand for further proceeding, in which they can amend their pleadings. And so here they decided to remand the case. And
good.
Right.
Okay, good. Thank you, Catherine. All right, Macy, I think you're next. You're here.
Yeah, I'm here.
All right, Macy, we'll get to the repeal in a minute. But why exactly did New York have this law? What was the purpose of this law before it was repealed?
To keep firearms from leaving the city, to essentially limit firearms just out in the public.
But why? You could drive, 45 miles from Staten Island to the Bronx and cross several bridges to get there and bring the gun, or you could drive 5 minutes from New York to New Jersey and shoot there at a range. Why? What was the purpose of this law?
The firearms in the state or in the city?
Why though? Why is that an important state goal?
Because then the government not knows where they are, but knows that they're limited to a specific area.
But but why is that important for the state to have? By the way, this is not carrying a gun in your holster. It's carrying it locked in a box in your trunk. If you don't have a car and if only for public transit, too bad. You can't do this at all. You can't bring in a bus. So it's only people in vehicles. But it's locked in a trunk. Why can't people train at a range near their home? What's the state's interest in keeping it inside the city limits?
I don't know how to answer that more than I already have.
But why does the state have an interest keeping guns inside the city? If someone wants to go to a shooting, a competition, target practice competition in Pennsylvania, for example, what's the state's interest in preventing that from happening?
I think the idea is safety. If you have limitations on where you can have your registered firearm, then you're lessening the opportunity for it to be somewhere else. Does that make sense?
No, I get you. I'm not trying to be difficult.
Yeah, you are.
Fine. Maybe I am. I guess I'm always trying to be difficult. Then I'll ask one more question. I'll let you off the hook, right? Why does the state have an interest in limiting where you can bring your gun? Why is that something the state cares about? I understand you can't carry it openly, but if it's locked in a box, why can you be able to travel 45 miles from the Staten Island to the Bronx, but not 5 miles from Staten Island to New Jersey? Why is that different?
Like, it's different. Well, I mean, first of all, it's a public safety thing. They want to keep their own city and their own state safe. But then, like, it's a jurisdictional issue. If you go into New Jersey, then there may be a different set of rules.
Okay. All right, Michael, are you here?
I'm here.
All right, Michael, let's just assume that this was a valid public safety law for the reasons Macy said. The government defended it before the trial court. The government defended it before the Court of Appeals. Did they have any objection to the law at any point during the lower court review?
I mean, I think there's some skepticism, but no real, opposition.
Okay. What happened as soon as certiorari was granted?
I actually do not recall.
Did you do the reading?
I did, but I did it in haste, unfortunately.
That doesn't count. Denver, you here?
Yes.
What happened as soon as certiorari was granted?
Well, it looks like they remanded the case, right?
No. What did New York do once certiorari was granted? Did you read the case?
Yes.
No, please don't put it in the chat. That's very disrespectful. I'm trying to teach a class here. That's not how it works. What did New York do here?
Change the law.
No, that's not enough. How'd they change the law? You don't know.
I guess I gotta pick that up.
No, this is not good. If you guys can do the reading, this is not going to work for class today. Caitlin, you here? Caitlin? What did New York do here?
They changed the law to basically, I'm looking at my notes. Because the dissent started talking about how we changed the abortion laws from having 5 to 4, would that make a difference? And
All I'm asking is, what did New York do? What exactly did they do? The city did something, the state did something. What happened here?
I believe they allowed them to carry outside of the city, but there were still restrictions on that.
This is not good, guys. Alexandra, what did this? This is not good. Alexandra, what happened here?
Well, they amended the rule that prevented the transport of firearms from the second home. They amended it basically to where the petitioners got what they wanted. They could take their guns from, like, they could move their guns from house to fire range.
And what did the state do to make sure this case was moot?
What did the state do to make sure this case was moot? They basically said that they gave the petitioners what they asked for.
Let me ask the question differently. We have a city and we have a state, right? A city law can't conflict with a state law. What did the state do?
Well, they changed their law too.
And would it be possible for New York to reenact their law?
No, because then it would be in conflict.
Okay, good. All right. I got to tell you, if you guys can do the reading, I'm just going to cancel class. If I get the sense that this is not going to work, I'll just do the reading on your own. I'm not going to waste my time here. That was really bad. On the last day of class, a really bad way to leave an impression. It's disappointing. New York changed the law. The state made it impossible for New York to reenact this regime. All right. So let's just say that Macy's correct, right? And that there is some public safety rationale. I'm not trying to be difficult, and maybe I am, but the idea that trying to limit where people can bring their guns locked in a case to a shooting range is a strange one, right? If you have two houses in New York, let's say you have a house in, you have a house by the beach, it was basically illegal to bring your gun from one house to the other locked. If you had a shooting range that was 5 minutes away in New Jersey, and the other shooting range was 90 minutes away in the Bronx, you had to then drive 90 minutes to another range, crossing several bridges, going through many different neighborhoods. This law is pretty close irrational. It just reflects a general dislike of guns, and they want to make it as hard as possible to own a gun, hard as possible to remain competent to have one. The reason why this law exists and no other state has such a law is just they don't like guns, right? I think Alexandra was getting at with it, or maybe it was Caitlin getting the dissent. What happens if, we have cases involving abortion where you have to drive a certain amount of distance, where you can't have, you can't leave the state to get an abortion, or, you can imagine the type of law you have. I suspect those laws are probably coming the other way in New York. All right. But New York takes every step to moot the case, and I actually think the case was moot. I think Alito has some fair points. But at this point, there wasn't much left for the court to decide. The plaintiffs got their relief. Today, this exact same case involving the New York State Pistol and Rifle Club is back at the court, involving the right to carry more generally. And the court has not seemed willing to take that case. All right. Brianna, you here?
Yes, sir.
What's Justice Kavanaugh's point?
A lot. So he was agreeing with everything they said, and basically, sorry, that was a really short concurrence.
It's not a lot. It's 2 paragraphs. You wrote very little, so.
That was super small. He was basically just agreeing with it all, and then he was saying that it was new. Well, I don't know what else to say. He was agreeing with it all. Like, he literally said, I agree with everything.
But then, what did he think the court should do next?
That they should address the issue like this one's mute. He agreed that this case was moot, but that they should address this issue regardless too. If that makes sense.
They should take another case.
Yes, but addressing this issue.
So did the court actually take another case?
Not until we're still trying to figure it out.
So this is one of these cases where I think Justice Kavanaugh got played. Kavanaugh's here saying, well, I think this case is moot, and I think he's probably right about that. But he said, there are several other Second Amendment cases on the docket. We should take one of those. Let me give you a preview of what would happen. About a month later, after the case was decided, there were 10 gun cases in the docket. The court denied reviewing all 10 of them. So Kavanaugh got played. I think he thought there were votes to grant in another case, and there weren't. In fact, I think Kavanaugh actually wrote the per curiam opinion. It just reads like something he would write. That's my theory. When the opinion is per curiam, that means it's by the court. We don't know who wrote it, but someone obviously wrote it. I think that was Kavanaugh, probably with the chief helping, if I had to guess. Okay? So I think Kavanaugh thought the votes would be there, but there weren't going to be votes there. Yeah, Grayson, go ahead.
Oh, I just want to ask. So if you think he wrote the per curiam opinion, he can still write concur.
Yeah, it's one of these weird things where judges concur to themselves. It's weird. It's weird. They do that.
Okay.
Yeah, it's a weird thing, but you're absolutely right. It can be done. All right. So again, Kavanaugh concurs. Then we have this dissent from Alito, Gorsuch, and Thomas. And Justice Alito is pretty pissed off, right? That was Brianna. Not Sarah. Jessica. Why is Alito pissed off here? He seems pretty angry. Jessica?
He is wildly angry because he feels like what New York did was essentially manipulate the court. By doing this, they prevented the court, they rendered it moot, so that sort of is something we're not supposed to have in the court, and that robbed the court of the opportunity to consider something that was really important.
Yeah. Why do you think, Jessica, New York went through all these hoops to repeal and moot out the case?
Because they knew they were going to lose.
Yeah.
They knew that they were going to get smoked.
Yeah, so they just got rid of it. Can you usually do this? Can lawyers usually try and like frustrate the court's review? Is that usually frowned upon?
I'm sure it's frowned upon, and I also think it's probably often harder to do than this. Like, this wasn't really
Easy, yeah.
When I read it, I was like, oh, well, I mean, that wasn't that hard. But it was interesting to think about it.
It actually was really hard. I think, Jessica, your point is right on target, no pun intended. There has to be coordination between the city and the state. It wasn't enough for the city to repeal their ordinance. The state had to sign a law to basically what's called preempt or knock out the local ordinance, and the governor to sign it. So there was coordination at every level of New York government to kill this case, and it happened very quickly. It's remarkable.
There must have been so much scrambling and so many people calling each other like, holy crap, they took it. Oh my God, what are we going to do? Oh God.
Yeah. No, it's right. I can imagine Governor Cuomo said more than, oh crap. Maybe had some other 4-letter words to say, but yeah. Yeah, you're exactly right. Thanks, Jessica. So Alito is annoyed because the government here was trying to frustrate the court's jurisdiction, right? And trying to take the court off the docket. And again, they vigorously defended the law before the trial court, before the Court of Appeals. And they identified interests, much like Macy said, like we're doing this to limit where guns can be. And if we limit where guns can be, we can limit gun danger altogether. In other words, if you just keep the gun in your house, right, then, you can't harm people outside the home, right? Isn't that the thinking? I mean, that's more or less what Macy was saying. And that's what the government argued at every level. If it truly believed that, it wouldn't have repealed the law. But they were so afraid of losing and setting a nationwide precedent that they rescinded the law and they made it illegal to reenact the law, which is just stunning to actually pull this off. Again, I think it was moot. I do. They did everything in their power to moot it, and they mooted the case. Then Alito was pissed about something else. Several senators filed a brief, Senator Whitehouse and others, and this is remarkable, where they basically said, and you can click on the link. I have the link in the brief. I'm not exaggerating, that if the court rules in favor of the gun owners in this case, where there's arguable mootness, then there should be maybe retribution against the court. Basically threatening court packing in a Supreme Court brief. Stunning. You can read the brief. There's a link right there. I've got a link to it. It's on page 3 of the PDF. Absolutely stunning that they would put this in a brief. And, who knows? Maybe the court blinked. Maybe the majority said, oh, crap, I don't want to have to deal with this court packing. Remember Roosevelt, right? And so they blinked. Now we know the court packing thing is just, this is before the election, but ain't going to happen. Not going to happen. Biden's not interested, so this is all just fake. Yeah, Grayson, go ahead.
Sorry to ask another question.
No, don't apologize. Please, go ahead.
Maybe I just don't have that firm a grasp on the procedural issues, but in writing the briefs to say that they shouldn't consider it, is that really necessary if the court finds it's moot, or they're just going to say it's moot? Why do they have to fight so hard to say we don't need to worry about this because it's moot?
I'm sorry. When you say who's filing the brief, New York? I'm not sure what you're talking about.
Yeah, I thought it said in the case after they changed the law, they filed briefs saying.
Yeah. Well, okay. Yeah. It's a good question, Grayson. So the posture of this case is actually messy. So usually the way it works is the court grants review, and then the government's brief is due a couple months later, right? Just to, argue the case. New York didn't want to file a brief defending the law because they'd repealed the law in the meantime. So they didn't even file a brief defending the law. They simply went to saying, we have a suggestion of mootness, and they suggest the case be taken off the docket. And that's how this case went around. Basically, New York would not even defend the law in their briefs because they repealed it so quickly. The scrambling that Jessica mentioned happened within a month. They had the entire thing taken care of. Yeah, there was another gun case which was referenced in your reading called Wrenn, W-R-E-N-N, from the D.C. Circuit. And the D.C. Circuit actually ruled in favor of gun rights, that there was a right to carry. D.C. chose not to appeal the case. They didn't appeal the case to the Supreme Court because they were afraid of losing. So they just let their gun law go. To avoid setting a nationwide precedent, they just let it go, which is just remarkable that the way these things go. All right, thanks for that, Grace. Good question. All right, so the court, Alito's annoyed. This case is not moot. When the court has jurisdiction, they should exercise the jurisdiction. And now you give incentives to other plaintiffs or other defendants to try and moot cases out when they get to the Supreme Court. More recently, we saw this with the COVID case. I've written about it incessantly. I'm tired of it already, where governors would defend their COVID policies until it gets to the Supreme Court, and they would just repeal the policies. Happened time and time again. Cuomo did it. Newsom did it in California. They would defend their policy, and as soon as the Supreme Court gets the case, they say, okay, we're going to repeal this policy. I analogize it to a game of whack-a-mole. Remember at the carnival whack-a-mole where you hit the mole and the other one pops up and you keep hitting it? You can't win. It really brings back the massive resistance during the civil rights era where the schools would do everything to frustrate appellate review. It's not a good history, but it's the closest history I can think of. All right. Finally, though, in part 4 of the opinion, Justice Alito explains why this carry law violates Heller. Dusty here? Dusty? No. Christina, you here?
Hi, yes, I'm here.
So why does Alito think the New York law runs afoul of Heller?
So they reference Heller and they state that bearing arms implies something more than just the keeping of arms. So in order to learning to handle and use them in a way that makes those who can keep them more efficient, and that this is a concomitant of the Second Amendment.
Good.
And by restricting it, it violates that.
Good. Thank you so much, Christina. Heller didn't involve a carry case, right? Heller involved the right to keep a gun in the home. But there's a lot of language in Heller which suggests that you can carry. So, for example, the bit about, you can't carry in sensitive places, that would suggest that you can carry in non-sensitive places, right? Every facet of Heller suggests there's a right that's not limited to the home. Didn't say it expressly, but if you read Heller carefully, you can. The lower courts have just run away from this holding, and they sort of assumed at every juncture that it does, but they don't really decide it. That's what they would do. We assume, but don't decide. And then they find the law passes constitutional muster. We also have the case of Ezell. Remember Rhonda Ezell from Chicago, that the right to train, right? There's a precedent. In fact, I think this case actually split with the Seventh Circuit on the right of training. See, Chicago said no gun ranges in city limits. New York said only guns in city limits, right? And only gun ranges in city limits. Almost the mirror image of Ezell. But this law poses a substantial burden, if you will, on the right to bear arms because you have to drive. And by the way, this is a point that Texans have trouble understanding. Not everyone in New York has a car, right? In Texas, everyone has a car. Most people in New York travel by subway or bus. You cannot bring a gun on a subway or a bus. To say you have to go to a range, 50 miles away in the Bronx is basically saying you can't go anywhere, right? It's not feasible. It's just not practical to get there for a lot of people. So these sort of restrictions basically make it impossible to train because you have to go so far away. All right, for a lot of people. All right, then you have Part 4B of the opinion, which Justice Thomas does not join because it talks about the sort of public safety rationales. And Alito responding to what's the rationale for this? Why can't you bring a gun to a range in New Jersey, right? How hard it'd be to figure out where you're going, right? If there's any danger that happens, the guns are registered. These laws are just designed to make it burdensome to have a gun. The way to think about it is that Texas tries to make it burdensome to have an abortion, and New York tries to make it burdensome to have a gun. It's just these are laws meant to burden rights for the sake of burdening the rights. That's what these laws do. But the case is dismissed. Nothing happened. New York State rifle. All right. Any questions in the first case? Any questions in the first case? No? Oh, Caitlin, go ahead.
I guess my only question with this case is if you were to someone ask a question that would go back to this case on an exam, would we just really use the dissent for the most part in their argument?
Yeah, it's such a good question. I wish I had for you a majority opinion that gave the other perspective. I almost feel guilty assigning these two things. It's only Thomas and Alito, right? Like, I would like if Kagan or Ginsburg or someone wrote about the other side of the issue. We don't have that. So I actually feel guilty assigning this. In the past, I've assigned some lower court opinions, which I've sort of moved on from. We have the Stevens dissent in McDonald. I'm sorry, the Stevens dissent in Heller. We have majority opinion in the Cantor case from the one that Justice Barrett was on. So you do have some readings assigned that give the other side, but don't feel you're bound to follow Thomas and Alito. I don't think that's fair because there are definitely two sides to these issues. Unfortunately, I don't have one for you because the court doesn't say anything. It would be nice if we had something from the court on why the right to carry is not protected. We don't have that. So I get
I just hope these cases keep referring back to Heller, and it's kind of like this big overarching case. And I was wondering if should we stick more towards those arguments maybe and like fall back on these as needed?
Look, Caitlin, you're asking such a good question. It's a very insightful question because I litigate the Second Amendment. I do this for a living. I don't know what the answer to that question is. Right? I feel like I'm in this weird state of limbo where for 13 years we have no idea what the law is. It's a very strange world where the court refuses to resolve circuit splits, which is one of the points that Thomas makes. Even if the court held that the Second Amendment doesn't protect the right to bear arms, I'd be happy. Just get it over with. Pull off the Band-Aid, so to speak. Just end it and tell Thomas you're wrong, Clarence, and then let's move on with our lives. But instead, we're stuck in this weird loop where we don't know. And every student year, if you ask me the same question Caitlin's asking, it's a very good question, and I can't answer that question. So I don't know. I'm sorry. I wish I could answer your question, but I don't have an answer for you. I was hoping sincerely that for the next edition of the casebook, the 4th edition, we would have a actual gun case from the Supreme Court, and it's not going to happen. We've got now 3 editions of the casebook without any new gun cases, which is remarkable. That's why we have all these lower court opinions and dissents, which don't really mean much. All right. Thank you, Caitlin, though. Good question. All right. Who's up next? Sienna, are you here?
Yes.
Okay, Sienna, what was Roger v. Graywall about?
I believe there was a man from New Jersey, and he had to travel around like dangerous areas of the state, and he wanted a handgun license, but he couldn't receive one because the law in New Jersey made it really, really difficult to get. Yeah. So, what exactly, Sienna, did Rogers have to show to get a concealed handgun license? Specify in detail the urgent necessity for self-protection. So I think he had to say, like, there's a person, this guy is trying to kill me or something like that. Just not like a general, I go to dangerous areas. Yeah, that's very good. Thank you, Sienna. So there are 2 general types of concealed carry laws in the United States, right? The first is what's called shall issue, which is what we have here in Texas and about 30-something states. I've lost count. Shall issue means the government will give you a carry permit unless you have some reason not to give it. So if you have criminal history or you've had a history of mental illness or you have some reason why you're disqualified, you're a felon, right? You get it. And in some states, you're required to have the permit granted within X days, right? They're required to give it to you. That's what's called shall issue. New Jersey, as well as New York, is what's called a may issue jurisdiction, which means the decision to give you a gun license, a handgun license for concealed carry, is discretionary. And usually you have to show what's called good cause. And it's framed different ways, but good cause means you need to have some reason. Now, everyone has a reason why they want a gun, otherwise they wouldn't have one, right? I want to feel safe, I want to protect my family, etc. That's not enough in New Jersey. You have to show a specific justifiable need. That is a need that goes above and beyond what normal people would ask for. Now, I think he has one in this case. He repairs ATMs in dangerous neighborhoods. That seems like a good reason to have a handgun. But in New Jersey, they don't give it to anyone unless you're powerful and influential. Celebrities get them all the time, right? Celebrities, Donald Trump in New York had a concealed handgun license, right? He didn't need one. He had bodyguards. But if you're influential, you had one. Senators in California get them, if you know the sheriff, right? Celebrities in California get them. Regular people don't get them.
So it's very much a preferential game of favoritism. That's how these things work. So Graywolf challenged this regime as a violation of the Second Amendment. The court once again denies review. And we have a dissent from Justice Thomas, joined in part by Justice Kavanaugh. And again, I just want you to understand the timing here. About a month earlier, Kavanaugh said, well, we have these other cases in the docket, including Rogers. Let's grant one of those. And then a month later, denied. So again, Kavanaugh looks like a schmuck, right? He comes off looking like he got played. After the term finished, a CNN journalist who I trust reporting, her name is Joan Biskupic, had a report. And according to the report, Chief Justice Roberts signaled that if you guys grant the gun case, I'm going to uphold the law. Right? So apparently Roberts like, I'm going to uphold this law, so you better not grant. Almost like try me, right? Go ahead, make my day. So the conservatives said, we would rather have this limbo without clarifying the scope of the Second Amendment than have Roberts limit the Second Amendment to the home. Basically, just Heller, that's all you have. That was before Justice Ginsburg passed away. Afterwards, we now have another justice who, as far as we can tell, hasn't granted any gun cases. So maybe the law is still in this flux area. But I at least want to walk through the Thomas opinion for a bit to at least give you one side. And I take Caitlin's point. Her point is well made. What's the other side, right? We were just talking about Justice Thomas because not everyone agrees with Justice Thomas. I get that. But that's all we have for this case. That's all we have. Thomas explains that in the decade, now it's almost 13 years since Heller, the lower courts have struggled. And they sort of adopted this, this two-factor test, right, that asks whether a right is within the core of the Second Amendment and, to what degree is the right being burdened. And Thomas says, where did any of this come from? Right? Where did any of this come from? Right? This is not consistent with Heller. All right. Indeed, Justice Thomas explains that in many regards, the Breyer dissent, right? The Breyer dissent is being treated as if it was a majority opinion. Right? This sort of interest balancing where you weigh the interest in each side was what Justice Breyer advocated for. This is what I think I told you last week. In many regards, the most influential opinion from Heller was not Scalia. It was Breyer. Breyer is underrated. The courts are balancing interests very carefully. Then we get to part two of the dissent. And this is the part that probably Caitlin would most want to rejoinder on, which is about the historical basis of the right to bear arms. She's smiling, right? I don't want you to take Thomas's gospel because other courts have vigorously disagreed. And if you are so curious, you can email me. And I'm happy to give you some contrary opinions. I don't want to overload you, but there are contrary opinions. But Thomas explained there's a long history of this right to bear arms, and that bear means carry, going back hundreds of years to the English Bill of Rights. Many state court decisions recognize this right to bear arms in the early 1800s. That at a minimum, there has to be some right to carry outside the home. Right? The framers didn't draft the Second Amendment so you can carry a gun from one room of the house to the other, or so he says. Of course, this presumes Heller is correct, which not everyone agrees. But I think at this point, they're taking Heller as the starting point. Okay. He also gives some history which you may not know about. But the right to bear arms isn't only what was happening at the time of the American Revolution and during the ratification of the Constitution. We also have to think about the 14th Amendment era. Right? During Reconstruction, the right to bear arms was very important to the freedmen. If you were in my class last semester, we studied U.S. versus Cruikshank, the Colfax Massacre case. This is a case where basically a bunch of white supremacists set a building on fire and burned a bunch of black people to death and then slaughter them. Right? This was actually a black militia that's trying to defend themselves against this white militia. Right? The right to bear arms was extremely important in this era. And I'd argue, and I'm confident making this argument, whatever the right to bear arms meant in the 1790s, it meant something even greater in the 1860s, right? Even if Heller's wrong, McDonald's right, which is why all this outrage about Heller, what did the militia mean? By the time you get to the 1860s, the right to bear arms was very much individualized. There was no more state militia like there was in the 1790s, right? You had people defending themselves against the Klan and needing the right to bear arms. If any of you saw the Harriet Tubman movie, it's on HBO. It's quite good. I recommend you watch it. She was gun-toting, and she bore arms quite well to defend her people on the Underground Railroad. It's actually a well-done movie. I liked it. It's on HBO now if you get a chance to watch it. All right. But the sort of history from the Reconstruction era is just kind of ignored, the lower court opinions. All right, so then we get to the court's own unwillingness to take these cases, right? What is going on, right? Why is the court unwilling? And Thomas is basically calling out his colleagues, saying, look, we have a massive circuit split. One of our jobs is to resolve circuit splits. Any other circuit split we've already resolved, but not this one. And I can tell you, as of April 19th, 2021, this split won't be resolved for at least another year. Probably 2 years at this point. And we're in the same exact position we were when I was a 25-year-old law student back in the day. We're nowhere different than we are back then. All right. Questions on Rogers? Question on Rogers? Nothing? All right. Questions? Anything else you want to ask? Baker, go ahead.
Actually just have kind of a more general question, and maybe I should know this, but whenever like they're deciding what cases to take, like how exactly does that work?
Good
like,
question.
Is it a majority opinion or?
Yeah, it's a really good question. So there's a very elaborate process, right? Almost every Friday during the term, the court has what's called a conference. And the court has a private conference where only the judges are allowed, no clerks, no staff, which is why these leaks from conferences are so problematic. But they have this conference, and the justices go through every petition that's up for conference that week. It might be hundreds of them. In order to grant a petition, there have to be 4 votes. It's called the rule of 4. So to hear a case, you need 4 votes, but to win a case, you need 5. And it's apparently the case that the conference, the justices talk about the merits, and they say, well, if you grant this way, I'm going to rule in a certain direction, which is what Roberts does. And then you have what's called a defensive denial, which to avoid losing, you just deny cert. So there's this if you ever did economics, this very bizarre game of game theory where you're either granting or denying defensively to avoid getting a negative decision. We don't know exactly how this works. In fact, I don't know how much discussion goes on at the conference, but from what I gather and assume, there's more than you think. And that even before the case is even argued, the justices are arguing to even take this case because here's what I'm going to rule. So, I mean, good luck with the parties. It doesn't matter what you argue. The die has been cast beforehand. Today, certiorari is almost entirely discretionary. They have almost absolute discretion to take cases with a few exceptions. In the past, there were many more what were called mandatory jurisdiction cases where they had to take the cases. But today, it's almost completely discretionary. It's actually remarkable. Of all the various court reform proposals, perhaps one of the best ones would be a mandatory jurisdiction regime. So the court can't game the system like this and pick and choose cases. In the olden days, if there was a constitutional decision, it would actually begin before a 3-judge panel and have a direct appeal to the Supreme Court. I would be very much in favor of that. Now it's this nonsense thing with like 18-way circuit splits that benefit no one.
And so, like, you don't know how they voted in that conference?
No, private. We have no idea unless it gets leaked, which is why these leaks are really damaging. They shouldn't leak, but they do, unfortunately. The votes at conference are not revealed. unless a justice dissents. Now, if 3 justices dissent from denial of certiorari, like what you had in you've had in some cases, you can do the math and figure out who voted to deny cert. Right. So in other words, if 3 justices are willing to grant cert, you know that 6 voted to deny. Because you need 6 to deny, you only need 4 to grant. So if at this point we know that Alito, Thomas, and Gorsuch want to grant the case, we know who the other 6 are. We know that Barrett, Kavanaugh, and Roberts are not willing to grant. So you can do the math that way. But they have to. One of the reasons why we have these dissents is to signal to the public, look, this is not me, right? Thomas, like, I want to take this case. It's my colleagues who don't. Good question.
Great, thank you.
My pleasure. Ryan, go ahead, and then Grayson. Oh,
my question is
good.
Kind of the piggyback on that, right? So if it only takes 4, and up until just several months ago, we're looking at 5 or 6 months ago, there was a 4 supposedly liberal justices and Roberts. So Roberts doesn't want to take the case, but if they do, he'll rule against it. I'm surprised that the 4 ostensibly liberal justices didn't take up a Second Amendment case and force his hand, if that's really
so I think there was a deal. I think there was a deal. There were some other liberal cases the court also denied review on. I think they had a deal. I wrote about this last term. Again, this is pure Josh Blackman speculation. You're welcome to ignore me here. This is not in the book, but I think Roberts and Kagan worked out a deal where they denied some liberal cases and denied the gun case. They just denied it. And it's like this weird compromise.
Seems like a mini Senate or something.
Yeah, no kidding. I'm going to start the minute poll if you need to go. I don't want to keep you past, but I do want to answer your questions. All right. And someone remind me about the Governor Cuomo story. I don't have to tell it now. Remind me next week. I'll do it next week. I wanted to make sure everyone's here for that. Grayson, go ahead.
When they're denying a case because it's moot, does that still just require 4 votes as well?
No, to dismiss a case, it takes 5 votes.
Okay.
You always need 5. Okay. Krista, go ahead.
Sorry, but that question made me start thinking, when they're in their little conference, is there any idea about whether they're thinking, will this pass strict scrutiny? Will this pass intermediate scrutiny? Because when we were talking about this first case, I started thinking, it sort of sounds like, as Alito was writing, that he was thinking, I don't think that this law really passes intermediate scrutiny.
No. Yeah. I think what Alito's saying here is this wouldn't pass any scrutiny at all. And I was not giving Macy, I was giving Macy a hard time. I'm sorry, Macy. But I was trying to give you a little bit of a hard time because this would only survive rational basis scrutiny. If you ask 2 or 3 questions, yeah, but why? Why couldn't they do it some other way? It fails. This is a very weak law that no other jurisdiction in the country has. I think it merely reflects a disfavor of guns. An idea is, well, if we keep guns in the house, they won't do damage. Well, sure, that's true. But people need to train. They need to get their gun serviced. If they have 2 homes, why can't they bring the gun from one house to another? Right? Why can you drive?
But you don't think they give a lot of thought to that when they're doing their decisions about whether to grant certiorari or not?
Well, this was a case deliberately because it was so simple. Even if the court declared this law unconstitutional, nothing would happen, right? It would not affect public safety in any way. It's not like saying, oh, yes, you have the right to high-capacity magazines. You have the right to an AR-15. This was such an insignificant law in one jurisdiction. It was like the perfect test case. The court could rule in favor of the Second Amendment without really setting in national trends, right? Even if the court ruled this law is unconstitutional, that wouldn't get you concealed carry, right? That wouldn't get you the right to have different types of weapons. It wouldn't let felons have weapons. It would be such a narrow ruling. That's why this case came up. It was such an easy case to rule on. It was like the perfect gun law case. And that's when New York had to go ballistic and repeal it in 5 seconds because they knew they were going to lose.
All right, thank you.
All right. All right, so I have about a minute and a half left. The Cuomo story will take longer than that, so I'll do it next week. So Denver, go ahead.
I had a question because I looked up some more facts on the Rogers case. So I guess with this thing that I was reading, this is that 0.02% of the state actually has a permit to carry guns. So if this case, obviously this would be speculating, but had this case gone forward, do you think that would have been a reasonable fit for that law to meet the government's interest?
I'm not sure if one connects to the other. I mean, even if you don't have a carry permit, you still should be competent using your weapon. And it's your weapon that you train on, right? Guns aren't interchangeable. You might train on one gun, but it's a little different weapons. So there's a value to having your own gun, having training.
But do you think would it have had to been like either or, like either everyone has a right to like access their firearms, or that New Jersey may just have to relax their? Do you get what I'm getting at?
Not really.
Would they have had to would it have been possible that they could have relaxed the requirements for carrying a weapon rather than just?
I don't think carry had anything to do with this case. This gun was locked up in your trunk, disassembled. This was not a function. Yeah, are you talking about Rogers? Oh, I think it meant New York case. I'm sorry.
No, I was talking about Rogers.
Well, if the court had declared the Rogers regime unconstitutional, then it would have affected all of the other states with May issue. That would have had effects. I'm sorry, right, so, I missed which case you're talking about.
Sorry. Would it have been just a general right to carry then, or could they have just had to relax their laws to
Well, it would be what's called May shall issue, that if you pass criminal background checks, you get a permit.
Right.
All right. I think I'm out of time. Thank you all for your attention. The minute poll is running. I don't know what I'm going to do with this topic next year. I have no idea. I was hoping I'd have a case, but now I'm 13 years in with no other cases. Maybe we'll skip it next year. I don't know. I'll have to decide. All right. No class on Wednesday. I'll see you on Monday. Or actually, I won't see you on Monday. Take some time to go over the exam from last year, question number 1. And I'll go over it a week from Wednesday. So I won't see you for a while. I'm sorry, guys. You'll miss me, I'm sure. All right. Talk to you soon. Thank you.
Professor, I have one more question real quick. You have time? Quick.
Yeah, fine. Go.
Sorry. So with the way that you said that the governors did with the COVID bills and the way that New York frustrated the purpose of this, do you think you'll actually ever hear one? Because if it gets there and they think they're going to lose, and then they just play 3-card money and move the ball again, and it never gets there.
Yeah, I think the court will just... The only way this works is if the lower court upholds the law and the petitioners appeal, and it's a law that can't be repealed. Like New Jersey is not going to repeal their gun law. It's not going to happen. Not going to happen.
Yeah.
The New York law was so insignificant they repealed it and they didn't care. But the carry regime is very important. They're not going to repeal that one. So that would be the case to take.
Okay. So maybe eventually.
Maybe. It's hope springs eternal.
Okay.
Thank you, sir. Thank you, Clay. Bye-bye.